Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will & Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, the flagship publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed some of the trademark and copyright lawsuits that are shaping up to be important in 2015. This podcast will discuss some ramifications of Alice Corporation versus CLS Bank International, a case that the U.S. Supreme Court decided about 1 year ago that concerned the patentability of software. Over the years, an answer to the question of whether software can be patented in the U.S. has been a little unclear, or at least not as clear as many people would like. Many courts have struggled to apply Section 101 of the U.S. patent laws, which states that, quote, any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, end quote, is eligible for a patent. Courts have ruled that laws of nature, natural phenomena, and abstract ideas are not patentable. Whether software falls into the category of abstract ideas has sometimes been an issue. When the Supreme Court agreed to hear the Alice case, many observers were hoping that the court would issue a ruling that would amount to a clear yes or no on whether software is patentable. The court didn't do that. Instead, the court showed how to apply a two-step test to answer the question on a case-by-case basis. That means that there isn't a universal answer to the question. Every situation needs to be individually examined. Let's review what happened in the Alice case. Alice Corporation accused CLS of infringing its patents that covered methods of computerized financial trading. The district court, which is the court in the U.S. where patent trials are held that the patents were invalid because they covered an abstract idea. Alice Corporation appealed that decision to the Court of Appeals for the Federal Circuit, which is the court that handles all patent appeals in the U.S. The Federal Circuit affirmed the district court, that is, it agreed with the district court and upheld its decision. Alice then appealed that decision to the U.S. Supreme Court. The Supreme Court ruled unanimously, agreeing with the district court and the Federal Circuit that the Alice patents were invalid. The court reiterated the two-step test that determines whether something is eligible for a patent. Step 1 is to determine whether the claims in the patent cover a law of nature, natural phenomenon, or an abstract idea, that is, something that is not patentable. If the answer to Step 1 is yes, then you proceed to Step 2 to determine whether the claims in the patent add something significant to the law of nature, natural phenomenon, or abstract idea. If the answer to Step 2 is no, then the claims are typically invalid. An upshot of the Alice decision is that you have to apply this two-part test to each case where software is the subject of a patent. In the 1 year since the Alice decision, the Federal Circuit has ruled on a handful of cases involving software patents. In all but one of those cases, the Federal Circuit has invalidated the patents at issue as a result of applying the two-step test. Generally speaking, the Federal Circuit has taken the position in those cases that the patents at issue merely covered abstract ideas. Those patents covered methods of reducing distortion in digital image processing, a computerized bingo game, methods of providing secured online sales, methods of showing an advertisement before showing free content on the Internet, and methods for scanning checks deposited into ATMs. Applying Step 2 of the test to these patents showed that the patents didn't add something significant. Instead, the court concluded that the patents generally recited using a generic computer to perform the methods that comprised these abstract ideas. Using the generic computer didn't add anything significant to the abstract idea, so the court invalidated the patents. Now, in the one case where the court upheld the patent covered a method of generating a composite web page. The court found that the patent was aimed to solve a specific computer-related problem, as opposed to taking an unrelated abstract idea and using a generic computer to implement it. This distinction was enough for the court to uphold the patent. Looking at these first few decisions since Alice provides a good practice tip when it comes to drafting patents that cover software. Specifically, it's important that the claims in the patent do not simply recite using a generic computer to perform a series of steps that arguably are nothing more than a mental process or abstract idea. These decisions were rendered after months, if not years, of litigation in the corresponding cases. But in some instances, the Alice decision has been shown to be applicable at the outset of litigation. If Alice is shown to apply at the early stage in a lawsuit, there's a likelihood that a court will invalidate the patents at issue before significant time and money are invested, effectively ending the litigation. In the 1 year since the Alice decision, there have been about 100 early-stage decisions in the district courts on whether a patent that covers some type of software or process is valid. A significant number of those decisions have answered no. Although the aggrieved patent owners can appeal those decisions to the Federal Circuit, the statistics so far don't suggest that the patents will survive. With this apparent harder line being taken against software patents, it makes sense to use strategies that reduce the likelihood of invalidation. For example, look for ways to draft the patent so the claims don't rely on the operation of a generic computer that uses generic computer hardware and generic computer commands. Instead, write the claims so they include specialized hardware or modify the operation of the computer. These are some attributes that might amount to the something more that's required in Step 2 of the two-part test. It's important to discuss this with your patent attorney when you're in the process of preparing a patent application. I hope that you found this podcast helpful. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@mwe.com. Thank you.